Okay, I think, ladies and gentlemen, I think we can begin our session. My name is Bartłomiej Kapica. I work at the Center for Totalitarian Studies at the Pilecki-Institut, and I'm honored to be a moderator of the upcoming discussion. And our topic is going to be crime without punishment, legal and political discourses on the settlement of Nazi and communist crimes. And I think the topic that we are going to touch upon is really important because I think it will give us an interpretation and opinion why those two regimes are perceived in a very different manner nowadays. And so I'm really waiting to enjoy our deep and insightful papers that are going to be conveyed by our honored guests. And the first one is going to be Professor Annette Weinke. Professor Weinke is a professor at the History Department of Friedrich Schiller University in Jena, Germany, and co-director of the Jena Center of the 20th Century History. She has written extensively on themes of post-war, post-communist German history and the histories of legal human rights activism, international criminal law, and transitional justice in the 20th and 21st centuries. She is also a co-founder and permanent member of the working group Human Rights in the 20th Century, as well as member of the working group of International Criminal Law. She was also a visiting professor in very prestigious American universities such as Princeton University. And Professor Weinke is going to present the problem Nuremberg for communism, post-unified Germany and the politics of international criminal justice in the 1990s. Professor Weinke, the room is yours.
Yes, thank you very much for the very kind introduction, and also many thanks to the organizers for inviting me to this interesting conference. So, what I'm going to do today is I want to start with some thoughts on the merits or the genre of speculative history. Then I will try to give you a glimpse on the varieties of West German policies of international criminal justice in the post-Second World War period. And then in the third part, I will tell you a little bit about Germany's coping strategy with communist crimes. So, roads not taken, or things could have happened differently. This is the catchy title of a new exhibition currently showing at the German Historical Museum here in Berlin. And this exhibition is conceived as an experiment in historical thinking and plays with the idea that history always hinges on contingencies and the Janus-faced nature of certain moments. So since February 24, 2022, which is the most recent dramatic turning point in European history, speculative history thinking and history telling has gained new currency. Prominent commentators of Putin's war raised the question whether the trajectory of post-Soviet Russia might have taken a different path if in 1991 a Nuremberg-style court had been erected. And so would the creation of an international court for communism have prevented the recurrence of Russian chauvinism and militarism with the attempt to investigate and adjudicate at least the most heinous Stalinist crimes, made the Russian population more immune against Putin's blunt history propaganda and this glorification of the so-called Great Patriotic War. And as it is often the case in the genre of speculative history, raising the question usually means knowing the answer. And in this vein, the prominent human rights activist Nathan Sharansky recently argued that by not staging a trial against selected politicians and state functionaries of the former Soviet Union, the international community had definitely missed a unique historical chance. And a guest, so Sharansky, the Soviet Ukrainian Jew and a former close ally of Andrei Sakharov, and he had been the speaker, initially he had been the speaker of the Moscow Helsinki group and a representative of Soviet refuseniks. And in a guest commentary for the Washington Post, which was published 2.5 months after the Russian invasion, and on the anniversary of the Soviet victory over Nazi Germany, he stated, I quote, "Because Russia never had its own version of Nuremberg, its history was never officially corrected. Only a few years after the fall of the Iron Curtain, public opinion turned nostalgic for Stalinism, whereas in Germany it was unthinkable after World War II to declare longing for the days of Hitler. In post-Soviet Russia, parties that explicitly invoked Stalin could still garner millions of votes. The Russian people remained trapped in a fake reality because they continued to believe in a fake history." So as Sharansky correctly stressed, the idea of a Nuremberg for communism was indeed far from new in 1922. One of the authoritative voices who first came up with the proposal was Vladimir Bukovsky, another prominent ex-dissident and prisoner who had been expelled to Great Britain via Switzerland in the mid-70s. And so he returned to Moscow in 1991 and became immersed in the constitutional struggles between the Yeltsin government and the Russian Communist Party. And he pointed to, so he came up with this idea of a Nuremberg tribunal for post-Soviet Russia in 1991, and he reiterated this in 1995 in his book Judgment in Moscow, Soviet Crimes and Western Complicity, by also pointing to the case of West Germany. The healing of West Germany became possible thanks to the Nuremberg trial. Only by covering and condemning all the crimes of the Nazi regime could the country move forward. So, unlike post-Soviet Russia, the political and academic elites in reunified Germany actually engaged in a controversial and passionate debate about the pros and cons of Nuremberg for communism, although the idea of a permanent international criminal court had been dormant during most of the Cold War. The caesura of 1989 led German politicians and legal experts to lobby for the project in the German parliament and on the level of the United Nations. And in this paper, I want to raise the question why Germany's self-transformation into a leading international force for accountability and against impunity paradoxically led it to take a rather reluctant stance towards an international trial of Stalinist or communist state criminality, and why, despite its relatively long anti-communist traditions, this attitude seems to have even hardened during the 90s. So, So I want to give you a general idea of these different varieties of phases in the country's policies of international criminal justice. So unlike its ideological rival in East Berlin, who, mostly out of tactical considerations, incorporated Nuremberg core crimes into international law already in '68, the democratically elected governments in Bonn preferred to keep their distance towards this unpopular legacy of the occupation period. And in this stance, politicians were backed by conservative experts of international law, not a few of them transient critics of Western international law, with a biographical background in the intellectual struggles over the Versailles Treaty and a candor for Nazi Großraum theories. So shortly after the Second World War, when their previous engagement with National Socialist law temporarily became a professional burden, members of the West German legal community focused on the alleged imperializing tendency of international criminal law. Not only did they reject the Nuremberg project as victors' justice, but they also actively accused the Western powers of imposing on Germany a legal policy of civilizational superiority. Then, in the Cold War era, the subsequent foundation of two antagonistic states and the resurrection of a limited legal sovereignty, West German positions towards Nuremberg became more flexible and its critique more nuanced. On the one hand, the Federal Republic would allow the prevalent, would follow the prevalent West European trend of reversing the results of a post-war anti-fascist retribution policies by abandoning the criminal investigations, overturning or not recognizing the verdicts and releasing Nuremberg convicts. It embarked on a course which had been labeled as a bourgeois recasting of Western Europe in the name of a conservative Christian-Jewish reconciliation. And consequently, Allied law was repealed while West Germany ratified in '52 the European Human Rights Convention with a caveat that it did not need to recognize the ECHR's citation of the Nuremberg Principles. So on the other hand, West German policies became embedded in what Sebastian Gehrig has pointedly characterized as the Cold War legal entanglements between the two Germanys. Against this backdrop, the FRG, a non-UN member until '73, paradoxically became one of the first states who in '53 joined the Genocide Convention. And this was at the time when most international law experts had declared the project dead already. So one can say that in spite of the fact that both the creator, Raphael Lemkin, as well as German expellee associations who were behind this move, had been lobbying relentlessly for the ratification, the genocide paragraph in the German Penal Code was never applied, not on Nazi criminality, and also not on communist state crimes. All in all, it seemed to have been a mixture of old, deep-seated aversions against the humiliating effects of Nuremberg and the traditional West-East antagonism, which prevented the FRG to take a more favorable stance towards international criminal law. And yeah, this hostile mood again became relevant in '88 when the UN's International Law Commission presented its draft code on crimes against peace and security of mankind. And together with its other Western partners, the Western German Foreign Office voted against the Commission's continuation of its work on the draft code. And this was at that time when there was a power shift in the UN, so the emergence of a so-called third world UN had led most Western states to take a skeptical stance towards the UN's international legal and human rights policy. So, and West Germany could, in a way, hide behind its Western partners and doesn't have to come forward with its anti-Nuremberg rhetoric at the time. So, in April, excuse me? No, I'm sorry. In '88, officials of Germany's Foreign Office, which was since May '82 led by Hans-Dietrich Genscher from the Liberal Free Democratic Party, had still publicly warned against applying the principle of universal jurisdiction. And this argument advanced by the Auswärtige Amt at the time was that this would make it possible for states to, quote, for states to impose their views on other states by means of criminal prosecutions, end of quote. But 3 years later, the Cold War had ended, and this reasoning no longer seemed to be in sync with reunified Germany's main allies. Following the reports that the Iraqi dictator Hussein had massacred Kurds in the northern part of the country, the United States and Great Britain called for the creation of an international war crimes tribunal, and in '91, Genscher submitted several statements to the UN Security Council in which he characterized Hussein's actions against the Kurds as attempted genocide. And in April 1991, Genscher's party colleague Cornelia Schmalz-Jacobsen praised the foreign minister for his resolve in advancing the issue of a Nuremberg-style ad hoc court against Hussein and justified this with the ongoing genocide. So the Bundestag's debate of '91 over the Iraq war did not mean an abrupt change or complete U-turn in West Germany's attitude towards international criminal law. Rather, it marked one of the historical junctures which paved the way for its later engagement for the establishment of a permanent international court. And so in hindsight, the international humanitarian crisis around the growing numbers of Kurdish refugees was indeed one of the first triggers which caused first realignment with the norms of human rights law and the Nuremberg principle. But this gradual adaptation process on the international level did not mean that all old orthodoxies would be suddenly disbanded. Rather than using the special historical moment of '89 to reverse the bogged pre-'89 course in its domestic jurisdiction, the German judiciary would stubbornly continue to adjudicate Nazi and also communist state crimes on the basis of the national penal code. This first wave of criminal prosecutions against the Communist Party and the state officials had already begun in the last months of the old GDR. And after the Unification Treaty of 1990, the project was then expanded greatly. I have to cut it short here, but in general, it was a very difficult, challenging project, it became obvious that due to the difficult legal environment, many GDR system crimes would remain unpunishable, aside from a few so-called excess crimes. And against this backdrop, and with the delay of almost a year, a controversy about the purpose and the direction of the ongoing trials evolved, in which former GDR dissidents took a lead. In September 91, Wolfgang Ullmann from the party Alliance 90, the Greens, called for a radical change, of course, and the theologist was convinced that the judicial processing of SED injustice had run into difficulties because it was pursued as a national project without any connection to international norms and laws. So he published this article, Trial of the King or Nuremberg Trial, question mark, and he proposed delegating the processing to an international legal authority. While CDU politician Wolfgang Schäuble reacted to Ullmann's intervention by conceding that the Rechtsstaat might indeed be unable to cope with systemic state crimes, important representatives of the FRG's political class took a rather reluctant stance towards the idea, and in December 91, President Richard von Weizsäcker expressed his deep skepticism and dismissed the establishment of an international tribunal for GDR criminality as unworthy of serious consideration. And in this stance, he was seconded by opinion leaders from the Hamburg weekly The Zeit, who felt that already the word would provoke unappetizing associations with real socialist people's justice, how we called this. So, and it must be left open whether Weizsäcker and the liberal newspaper were aware that 40 years earlier they had belonged to the most vehement critics of Nuremberg, and also within the scholarly community of German international lawyers, the idea received only lukewarm responses. The only exception was Otto Trifterer, a former student of Hans-Heinrich Jeschek, and one of the few experts of ICL in the old FRG. So I come to my conclusions. From today's vantage point, the 1990s were a high time for international criminal law, propelled by the lobbyism of states and transnational human rights organizations. The project surged and became an important identity marker for many countries around the globe. The Berlin Republic was one of the mid-sized powers which actively contributed to this process by supporting the revival of the Nuremberg-style tribunal for international core crimes. It positions itself as the vanguard of the new anti-impunity and accountability movement. This was an astonishing turnaround, given the fact that West Germany, due to its antagonism with the GDR, had been one of the most vehement and persistent critics of Nuremberg before '89. In the perception and self-perception of German political and legal elites, this engagement was the direct consequence of the fall of the wall and the subsequent task to cope with communist state crimes. The narrative that Germany's repositioning in the field of international criminal justice was a reaction to its mostly negative experiences with trials against high-rank GDR functionaries was advanced by several members of the government and the administration. Klaus Kinkel, who had replaced Genscher as foreign minister in 1992, was among those who made this causal nexus. And already during his first days in office, he stated that by furthering the cause of international criminal law, Germany had drawn its lessons from its difficult experiences with domestic trials. But Germany's policies of international criminal law did not unfold in such a teleological way. It was neither planned consistently, nor can it be described as a rational learning process. Contrary to the official telling, Germany's commitment to the creation of the ad hoc tribunals in the cases of Iraq and former Yugoslavia was not so much motivated by the anti-impunity enthusiasm after the end of the Cold War, but by the necessity to compensate for the lack of military engagement and the hastened acknowledgement of Croatian independence. And another important impulse was to contain the massive refugee crisis, which threatened to undermine the already fragile societal fabric of reunified Germany in the early 90s. So conversely, this meant that domestic prosecutions of GDR crimes in reunified Germany completely lacked the utopian and cosmopolitan visions of international criminal justice projects during the 90s. Instead, the project was conceived in a narrow and almost parochial manner and without any reflection of its transnational repercussions. Thus, the idea advanced by some East European voices that by accomplishing the task in a relatively efficient manner, the country had also acquired a moral and political responsibility to support a larger and multinational Nuremberg for Communism, unfortunately never found much resonance among Germany's political and legal elites. Thanks a lot for your attention.
Hello, hello. Thank you very much, Professor Weinke, for this remarkable presentation. And now we can move on to the next paper, which is going to be delivered by Dr. Tomasz Lachowski. Dr. Lachowski is a doctor of law, legal researcher at the chair of international law and international relations, faculty of law and administration of University of Łódź in Poland, and his PhD dissertation was devoted to the issue of victims justice within a transitional justice context. He has conducted his research in numerous post-violence states, coming to terms with historical injustices and mass atrocities such as Bangladesh, Bosnia and Herzegovina, Mozambique and Ukraine. His recent scientific research touches firstly the issue of post-Maidan Ukraine, applying at present transitional justice policies, especially concerning the use of a post-conflict justice toolkit in the ongoing conflict and a post-war reconstruction of Donbas and Crimea in the shadow of the ongoing Russian aggression. And Dr. Lachowski is presenting a paper, Homo Sovieticus to Russkiy Mir, the Kremlin's genocidal policy against the Ukrainian nation in the light of international law and the thought of Raphael Lemkin. Dr. Lachowski, the floor is yours.
Thank you very much, Mr. Chairman. Thank you, the organizers, for inviting me for this wonderful conference. It's a really privilege to be here among such great scholars and researchers. My today's presentation will tackle the issue of the ideological basis of genocidal policy of the Kremlin, the communist idea of Homo Sovieticus, the new Soviet man, and today's totalitarian as well ideology of the Russian Federation means Russkiy Mir, the Russian world, which at least up to my mind is the ideological basis for not just policy but for the crime of genocide. And just in order to show this perspective, I would like to, during my presentation, first of all, to show this historical and legal perspective of the Soviet Union's genocidal repressions towards not just Ukrainians, but also other nations of the Eastern European bloc, mainly those nations that were forced to live in the Soviet Union after 1922 or after the Second World War, and to show that those genocidal practices are more or less the same today, and with the knowledge and with the thought of Raphael Lemkin, who coined the term genocide in international law, it's better to understand this genocidal intent of totalitarian and imperial regime of Moscow in terms of Russkiy Mir. As we know from this yesterday's discussions, and of course because of we are observing the situation, the current situation in Ukraine, the range of different international core crimes which are being still committed in Ukraine is extremely high, starting from the act of aggression of the state and crime of aggression of the leadership, including Vladimir Putin and other of the Kremlin's authorities. My main topic is genocide, with those symbolic places like Bucha, like Mariupol, like Izium, like many other, unfortunately, cities which can be named as symbols of the genocide. But however, my key question for this presentation is, what is the purpose of the Kremlin's war against Ukraine, of the Russia's, Putin's war against Ukraine, and starting from this historical comparison with the Soviet Union's attitude towards not just Ukrainians, my main initial thesis is that genocide in the Kremlin's eyes is a tool that can uphold the empire. Like yesterday, Professor Agnieszka Misala has spoken about war crimes as a tool of conducting warfare, so I can expand this thesis to say that genocide is in the service of the empire committed by the Kremlin's regime. Comparing those two ideologies, so the Homo Sovieticus and Russkiy Mir, in theory we can say that they are completely different, because Homo Sovieticus was based on the communist ideology, so the value of internationalization and atheism, comparing to the Russkiy Mir, which is based on the Russian nationalists and chauvinism, as well as the strong ties with the Russian Orthodox Church. So in theory, they are on the opposite ways of, let's say, perceiving ideology of the state. However, they both were and are totalitarian in terms of the internal repressions and imperial in terms of the imperial aims of the Russian Federation as it was in the time of the Soviet Union. The most, I would say, symbolic crime of the Soviet Union, however, those crimes were many different, starting from 1920s, 1930s, oriented and different national minorities in the Soviet Union. For instance, the Polish operation in 1937-38 in the Soviet Union. However, I would like to talk a bit about the Great Famine, Holodomor, which also in the eyes of Raphael Lemkin was perceived as a crime of genocide. And this very symbolic poster, bracelets with the Ukrainian colors, national colors, which is based on the real hand of exterminated men in Izium, found in, I think, September or October last year by the Ukrainian army soldiers. The Great Famine, Holodomor, I think that we all know about this artificial man-made famine, which, of course, still raises many, many questions in terms of historical but also legal discussions, whether we can call it genocide. The Soviet Union narrative and the Russian narrative is that, first of all, that this Great Famine was not in unique situations, since different experienced, some other nations of the Soviet Union also experienced famine. So, and by the way, even in the Ukrainian language, many crimes of the Soviet Union are not called crimes, but they are called tragedies. It is also this kind of the outcome of the Soviet narrative that still can be found even among Ukrainians who oppose the Soviet Union and oppose the Russian Federation today. This second argument of the Russian Federation is that more concerning the legal qualification of genocide, that those tragedies were oriented at the kulaks, so not at one of the four protected groups by the convention, but by the, let's say, political or social group, which is not being protected. In 2010, also it was the last year of Viktor Yushchenko as a president of Ukraine, and his politics of memory was promoting the remembrance of the Great Famine. And during those last, let's say, days, the Court of Appeal in Kyiv has delivered a symbolic judgment in which Joseph Stalin, Vyacheslav Molotov, and other fellows of the Soviet Union or the Ukrainian Socialist Soviet Republic were blamed of conducting genocide against the Ukrainian nation. Of course, normally, in terms of criminal proceedings, a person who is not alive cannot be prosecuted. However, and also it is in the Polish law on the Institute of National Remembrance that's concerning the transitional justice or historical justice pillar, right to truth, the democratic state shall name the crime by its name. And here the Court of Appeal has delivered this judgment calling and naming the Great Famine as a crime of genocide. And the Great Famine itself was one of those inspirations, you can say like that, for Raphael Lemkin, who firstly as a teenager observing the situation in the Ottoman Empire, also in the colonies of the Western colonial powers, and then in the Soviet Union has thought about those mass crimes, the crime of crimes which were during those days not named by any kind of legal acts, neither international nor domestic during those days. Lemkin in 1930s, he prepared a famous paper for one of the conferences held in Madrid in Spain, 1933. However, by the way, he was not led to Madrid by the Polish Minister of Justice, since they thought that his paper, in which he called for incorporation of new types of crimes such as barbarity or vandalism, can be easily attributed to the Nazi Germany, since it was just after Adolf Hitler took power in 1933. So it was also kind of, this different perspective of political understanding of, let's say, legal concepts. And in these concepts, first of all, he told about the crimes which are committed against the groups. So not individuals, but the groups are the victims of such criminal acts. And those two crimes, the difference was, let's say, between methods. However, those two initial ideas were the basis for Lemkin to coin the term genocide in his famous book Axis Rule in Occupied Europe, which was published in the United States in 1944. And here we can see the definition coined by Raphael Lemkin of the genocide. And actually, Lemkin didn't think about genocide as a just physical or biological extermination. He thought about this crime as a coordinated plan of different kind of methods and means directed at disintegration of the political, social, and other, let's say, foundations of the society, of the nation. And also Lemkin told or wrote about two stages of genocide. First is the destruction of the national group, and the second stage, according to Lemkin, is always the stage in which the oppressor group is trying to impose the national pattern of their life on the victims. And since, according to Lemkin, it is not about just physical extermination, so we can assume that other means of cultural, political, social genocide can be attributed to the oppressors. And because of that, we can say that for Lemkin, genocide was always an imperial or totalitarian crime. Therefore, or in such conditions, the genocide can be committed. As we all know, Lemkin was also an advisor for Robert H. Jackson in Nuremberg. However, as Professor Szabas yesterday told, in Nuremberg, Lemkin failed since genocide was not part of the jurisdiction of the military tribunal in Nuremberg. However, then after the Second World War, he was one of the advisors to the UN, firstly to the resolution, and then to the, of course, Convention on the Prevention and Punishment of Crime of Genocide, and this famous Article 2, in which, of course, we all know the patterns, and here just physical and biological genocidal acts were included. Why was it done? How has it been done like that? It was because of the political position of negotiating parties, mainly the biggest powers in those days, and of course the same states are the biggest powers today. The Lemkin's concept of cultural and political genocide was dropped. Here, the political genocide or political groups that were excluded from the final version of the convention, it was because of the Soviet Union, who in their rhetoric and sham false argumentation told about these tragedies of different social and political groups. So because of that, genocides in the eyes of the Kremlin cannot be attributed to the Kremlin for those actions. However, Western countries also contributed for narrowing this definition comparing to the Lemkin's initial idea, since they were afraid of attributing their own actions in the colonies as this cultural genocide. So that's why comparing those two elements or two definitions, those biggest powers, the political powers, has narrowed the definition. And just after the Second World War, Raphael Lemkin started to openly criticize the Soviet regime, the Soviet crimes. It was let's say for the two reasons. First of all, in 1951, the Genocide Convention has entered into force, and then in 1954, so just 3 years afterwards, the Soviet Union has ratified the convention. Also because they thought that because of their negotiation activities, they didn't had to be afraid since the political or social groups were excluded from the convention. Lemkin started to cooperate with different minorities in the United States and especially and also in Canada of Eastern European nations like Polish, like Ukrainian, like Baltic states. And for him, those situations like Katyn massacre, repressions against the Baltic states, including mass deportation, and also the Holodomor, however, not just limited to the Great Famine itself, shall be named as a genocide in the light of the convention, since the convention was in force during those days. And just to show this very famous essay of Lemkin, which was delivered in New York in 1953 for the 20th anniversary of the Great Famine, he called the Great Famine or the Soviet genocide, because he thought about a broader perspective of repressions of the Soviet Union against Ukrainians as the largest, broadest experiment in Russification, the destruction of Ukrainian nation. And comparing this, let's say, new approach of Lemkin to his initial definition, we can see that he thought about the Soviet genocide of Ukraine in 4 steps. First of all, the first blow was against the intelligentsia and the intellectuals in 1920s and 1930s, just after the, let's say, fall of the Ukrainization policy implemented by Lenin in 1920s. So intellectuals were the first target. Then the independent Ukrainian church, autocephalic Ukrainian church, then the Great Famine itself, and here Lemkin told about the peasants as the repository of religion, folklore, music, the national spirit of Ukraine. So in other words, he thought about peasants not like the Soviet Union as a social or political group, but as an emanation of national Ukrainian group in the eyes of the Lemkin. And the 4th step is the resettlement of those territories of especially south and east of Ukraine by other nationalities and ethnicities, of course mainly by Russian, but also other ethnicities. So if we today speak about the situation in which in the south or east of Ukraine people speak mainly Russian, it's not a natural situation. It is a consequence of the repressions of the Tsarist regime and then, of course, of the Soviet Union and the Great Famine itself especially. So for Lemkin, here we can say that this imperial and totalitarian attitude of the Soviet Union was the foundation of those genocidal acts. And Professor told about the lack of Nuremberg, and it is true especially for the Russian Federation, the lack of Nuremberg for communism, since this transitional justice mechanisms were never applied in the Russian Federation. As such, after 1991, this myth of the Great Patriotic War was incorporated in the Russian domestic law, and it is still being strengthened by the last novelizations and amendments to the criminal code of Russian Federation, as well as the constitution of the Russian Federation, in which attributing the crimes of the Second World War to the Soviet Union is just a crime. And here, yesterday we talked about the use of international law, of course, in a sham false perspective in the contemporary Russia. In 2014 and 15, in the Russian Federation, the prosecutors opened proceedings against Ukrainians of committing genocide on the Donbas residents. So it is not just false propaganda, but also it was supplemented by the criminal proceedings of the Russian Federation itself in 2014-15 and subsequent years. And coming to my conclusion and also the last part of my today's speech, so comparison of those two historical and contemporary situation of the Kremlin's policy, we can look very briefly on the main thesis of Vladimir Putin's speech 3 years after the commencement of the full-scale invasion of 24th of February, when he told about this artificial forged Ukraine that only existed because of Vladimir Lenin, and called for denazification of Ukraine. But if we take into consideration this politics of memory, this great patriotic war in which Nazis were also the main targets, so not just German Nazis, but also collaborators during the Second World War, but however also other nationalities, like after the dissolution of the Soviet Union, firstly Lithuanians were called chauvinists. After the Maidan, Ukrainians were started to be Nazis or nationalists in the eyes of the Kremlin. So by the denazification in terms of this Kremlin's perspective, we shall understand it is as a de-Ukrainization, since as it was during the Homo Sovieticus time. So, okay, Ukrainians can exist, but only as a part of the huge, let's say, this imperial Homo Sovieticus nation. And the same is today, that, okay, they can exist, but just as a part of a Russkiy Mir, the Russian world, not just a separate independent nation. The same was repeated by Dmitry Medvedev in many, many occasions. Here I put this first statements when he openly called for de-Ukrainization, ethnocides for Ukraine. So it is another, let's say, another example of such way of understanding this imperial totalitarian thinking of through the lens of the Russkiy Mir ideology. And just to sum up those elements, whether we can call for the Russian genocide in Ukraine today, I would say that yes, especially it is more easy to find this, let's say, examples of genocidal acts according to the Article 2 of the Convention. At least 3 out of 5, like Mr. Koronevich yesterday talked about this transfer of children. Of course, it is, let's say, a very visible situation. Also the situation when it comes to the killing of people, not just Ukrainians of ethnical group, but also nationals, because there were different people belonging to the Ukrainian national group of even Polish, even Russian origin, ethnical origin, but they were thinking about themselves as Ukrainians. And the intent, which we know it is the most significant and difficult to prove, especially in the court, I would say that reading through Lemkin, we can say that those official statements, but also those examples of cultural and political genocides, which at least it is an indirect intent, proof of the intent, but however, up to my mind, it is direct proof of an intent of the Russian leaders to commit genocide on Ukrainians as a matter of imperial and totalitarian ideology, however, according also to the convention. And conclusive remarks for today. Of course, Russia today committed several heinous crimes against Ukraine and the Ukrainian nation. For me, those elements of Russia's repressions against Ukrainians, especially on the temporarily occupied territories, are nothing new, especially comparing to the historical perspective of the Soviet Union and incorporation of this Homo Sovieticus ideology today, Russkiy Mir. And just one last sentence. Professor told about the lack of Nuremberg II for communism. I would say that especially the states of the Central and Eastern Europe, like Poland, Lithuania, especially Lithuania and Ukraine, has, let's say, initiated this dispersed Nuremberg. So they were holding accountable not just their own communists, like in GDR, let's say Germany, but also the Soviet officials, like especially it is visible in Lithuania. Last years, many those kind of proceedings were concluded. So my final conclusion that Raphael Lemkin's idea of genocide as an imperial and totalitarian crime can show us, let's say, the more perspective also for this practical application of the convention to the current situation in Ukraine, in which, at least up to my mind, genocide is taking place. Thank you very much for your attention. Thank you.
Thank you very much, Dr. Lachowski. It was a great paper combining legal and historical perspective. And now we can move on to our next speaker, Dr. Oktawian Kutz. And Dr. Kutz was formerly a legal policy officer at the United Nations office in Geneva, and now he holds a position of assistant professor of law at the University of Warsaw after having graduated from Harvard Law School and the University of Warsaw. He's admitted to the bar in Poland and New York State. He has practiced law in international and boutique law firms as an in-house counsel, as well as in the government. Dr. Kutz was a Helton Fellow of the American Society of International Law and a DAAD Fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. His latest works consist of a monograph titled The International Court of Justice and Municipal Courts, an interjudicial dialogue, and he is also going to publish a book on the Supreme National Tribunal and the Polish perspective on prosecuting war criminals after Second World War. And Dr. Kuc is going to present the paper Prosecuting War Crimes, the Polish and Ukrainian Experience after the 1939 and 2022 invasions.
Thank you very much. Please let me commence with expressing my thanks for the invitation from the Institute, Pilecki-Institut, for hosting me here and be able to share some of my comments concerning the Polish experience after the World War II in relation to punishment of war crimes and drawing some parallels or comparisons with the most recent history in Ukraine after the invasion from February 2022. When I look on those two wars or armed conflicts, we can see in face some similarities, especially that they both constitute total wars that are not really targeted armed forces of the invaded countries, but rather nationals, cultures, and all those objects and subjects that are not really military in nature. What leads, of course, to unspeakable crimes that are committed on civilian populations, both in Poland during the invasion, occupation during World War II, and now in Ukraine. Nevertheless, when we look at more legal or normative and institutional background, we can see a lot of differences between those two situations, and I would like to share some comments on that. Let me start with some normative differences, normative environment differences. And I think this is well illustrated by the discussion we had yesterday about those formalities or the academic discussion about elements of crime of aggression or genocide, whether this is cultural genocide or whether it's not cultural genocide, what is the understanding of crime of aggression with the international law, whether it's a leadership crime or whether we can prosecute also regular soldiers. And those discussions were totally absent after the World War II. We didn't have any normative documents and instruments when we can have those discussions based on. Especially the two problems that lawyers after World War II had was, of course, the problem of retrospectivity of criminal law, whether we can prosecute war criminals, somebody that we consider to be war criminals, without having legal basis before the crimes were committed. And of course, what would be the legal basis for such prosecutions? And when we look at the World War II and the Polish experience, first we have political documents, as Moscow Declaration probably being the most significant document that has no legal meaning, let's say, and then we have, of course, international instruments like Hague Regulation that were not criminal in nature. They were not criminal in nature. They didn't provide adequate structure for prosecuting international criminals. So with that left, of course, the Allied powers had to adopt the International Military Tribunal Charter. And then we had the Nuremberg judgment from 1946. But again, those norms were very vague in nature, especially when we compare them to today's statute of ICC. When we have the war crimes, I think it's at least 3 pages long. All the elements are spelled out, and then we have, of course, the additional document specifying each element additionally. And then how Poland dealt with that? What was the Polish experience? I would like to share the comments on the basis of the Supreme National Tribunal that I researched. So it was the highest Polish special tribunal equipped or established for prosecuting the major war criminals that were operational in Poland. And so first, the main approach really was the adoption of this approach of double criminality. So the lawyers, mostly pre-war lawyers, very well-educated lawyers, adopted this double criminality approach, showing that at least some of the crimes were already in Criminal Code of Poland before the war was adopted. And then we also have them in post-war criminal acts that were adopted in Poland, especially the August Decree of 1944, that were not, that those lawyers were not very, how to say that, were not very comfortable using those Soviet-like legislation in Poland in relation to war crimes. That's why first they decided to look into the criminal code of pre-war Poland, and then also to the post-war legislation to address the problem of double criminality, of retrospectivity of law, and then additionally they supplemented this reasoning with the Charter of International Military Tribunal, interestingly, it was really done without any legal basis, because the ratification of the charter by the Polish authorities only took place in June '47. So it was at least after majority of, maybe not majority, but at least a significant number of criminal prosecution of war crimes took place. Nevertheless, they were the only instruments that were available at the moment. But nowadays, of course, Ukraine the situation in Ukraine is totally different, significantly different. We have, of course, Genocide Convention that was discussed here so extensively. We have ICC statute with listed element of crimes and possibility to refer situation as Ukraine did, even if it's not a party to the statute, that at least is some kind of authoritative expression of war crimes, crimes against humanity, genocide, and in some extent of crimes of aggression. We have, of course, very well developed jurisprudence of international and domestic courts in relation to international war crimes. That Ukrainian or other courts can lean on to supplement or to look for guidance. We have customary international law, at least in some fields of international criminal law. And of course, it cannot be underestimated. There is a very vibrant debate in academic community about international criminal law, international crimes, and so on. Then I would like to move to institutional engagement and involvement. So after World War II, especially as far as the Polish experience is concerned, there was no really international cooperation until, let's say, January 1942, when the St. James Palace Declaration was adopted by some of the Allied powers, including, of course, the government in exile of Poland. So we see that it was maybe not 3 years, 2.5 years after the commencement of the war. And it was the government in exile in London that was involved, starting from October '43, in the works and operation on UN War Crime Commission. And the government in Poland, I mean in Poland, territorially in Poland, of course the communist-led regime, was not present at the works of this body. So the Polish government, first in Lublin and then let's say in Warsaw Łódź, was not really involved in any international cooperation regarding the war crimes. The only link between those, of course, when there was the change of recognition in the government, was due to the involvement of Tadeusz Cyprian, who was first the representative of the government in exile in UNWCC, and then he became the representative of new Polish communist-led government in UNWCC, and it was the only link, I would argue, that allowed new Polish government to be at least somehow involved in the cooperation on the prosecution of war crimes after World War II. This was also quite problematic because the recognition of the new government and the appointment of the new representative in UNWCC led to the huge gap in the participation of Poland, whatever institution or government in UNWCC, what also led to the fact that the Polish perspective of the Nuremberg trial was significantly lesser than it should be. In the sense that the Polish representation in Nuremberg was late to provide adequate evidence. And secondly, it was only after Cyprian was appointed new representative that they were able to join Nuremberg team, unofficially, of course, because Polish delegation were never official in Nuremberg. And this led further on to this so-known Polish indictment, the Nuremberg. The Polish delegation was able to provide some additional evidence, like witnesses from Auschwitz and Treblinka that were testifying at Nuremberg, and finally they were instrumental and essential in preparing Hans Frank diary for the Nuremberg trial, and of course later also in Polish trials. But now when we look at Ukraine, again, the situation is essentially different. We have an involvement of ICC. The opening of investigation took place on the 2nd March, so it was not even 2 weeks after the commencement of the invasion. We already have the deployment of forensic and investigative teams from ICC, and the prosecutor Karim Khan claims that at least 21 more states are willing to send their own experts to Ukraine and finance the collection of evidence. We have, of course, the involvement of Eurojust, so it's the European Union Agency for Criminal Justice Cooperation. There was an established joint investigative team with, of course, Ukraine, Poland, Lithuania, Estonia, Romania, Slovakia, Latvia, and other countries willing to join as well. We have independent International Commission of Inquiry on Ukraine established by the UN Human Rights Council in March 2022. So again, it was just a few weeks after the invasion, that have quite strong, as far as of course the United Nations is concerned, investigative mandate, and we know that the mandate of this type of bodies is predominantly focused on collecting evidence for future criminal investigation, as in Syria, as in Burma case. There's of course a long discussion, diplomatic, political, but also academic, on the establishment of special tribunal for aggression. There was quite a long discussion yesterday, so I wouldn't delve into it longer. We have involvement of NGOs of different kinds that were really not present at the time of war crimes during the World War II. And then we have national investigation in domestic courts. At least 14 European Union countries has commenced some kind of investigation in relation to Ukrainian to crimes committed in Ukraine. And we have supported national experts in Ukraine, like there was, of course, French forensic experts sent, and there are many missions in this regard. So we can see that not only the extent of international cooperation or support in relation to prosecuting war crimes, it's much wider. In addition, also as far as timing is concerned, it's probably the first international conflict of that kind when the investigation and collection of evidence takes place not only during the ongoing hostilities, but also really few days, if not weeks, after the outbreak of any armed conflict. That being said, I would like to add something more, not only on international prosecution of international crimes, but something I would say might be labeled as jurisdiction of war, because the conflict in Ukraine is probably the first example of this phenomenon, when we see that it's not only battlefields or battlefields of steppes of Ukraine that constitute the real struggle between two powers, but it's also courtrooms of different international fora when this conflict is being at least scrutinized. And this is, I mean, it's evident that it's a well-thought strategy of Ukraine on the international level, because we have, of course, ICC as one of the forums where focusing on criminal prosecution. But with that, we need to mention that there's at least 43 referrals from member states requesting the prosecution to investigate. So this is already quite a support in the legal sense. Then, of course, we have case before the ICJ in The Hague, the case concerning allegation of genocide that was instituted by Ukraine. And here we have 33 interventions, all of them in favor of Ukraine. Whether there are some differences in legal understanding of the case, nevertheless, all of them are favorable for Ukraine. And here again, application was filed on 27th of February, so it was really 3 days after the commencement of invasion. And of course, Ukraine was able to secure preliminary measures order issued 3 weeks after the application was filed. And again, it's rather extremely rare that provisional measure are issued at the ICJ at such a short notice. It probably can be also attributed to the change of the president of the tribunal just a few months before the Ukraine invasion. Of course, now it's led by the judge from the United States. Then, of course, we have European Court of Human Rights. Here, the application was lodged by Ukraine on the 28th of February, and again, there were preliminary measures indicated on the 1st of March, so just 2 days after the application was filed. So at the international level is extremely rare, obliging Russian Federation to refrain from any military attacks in Ukraine. There are 23 interventions from member states at these proceedings, plus different NGOs. And importantly, I think there's also quite a significant number. The court does not provide exactly the number of individual cases lodged by private applicants from Ukraine. And they were also able to secure preemptive measures in March 2024. Interestingly, the tribunal quoted that many of those applicants are those taking refuge in shelters, fearing for their lives due to the shelling and shooting. This is quote, having no access to food, water, health, sanitation, and so on. Then we have quite a few cases, at least 30, but it's also quite difficult to be sure at the Court of Justice of the European Union. Those are cases concerning targeted sanctions against Russian officials and oligarchs. And when we take into account also the cases and the international fora that were launched or at least initiated before the invasion, but again relating to the Ukrainian-Russian conflict, we have additional case at ICJ. We have at least 4 cases at the European Court of Human Rights. We had one case at ITLOS, so International Tribunal for Law of the Sea. This is somewhat limited because it was only on preliminary measures. Then we have 2 cases at the Permanent Court for Arbitration in The Hague, and we have multiple cases of investment arbitration against Russia filed by either private companies or state-owned Ukrainian companies against Russia. This is, I think, quite important because all those additional proceedings in the international fora not only have very strong propaganda. I mean, propaganda is maybe not the best word. It's an instrument fighting Russian propaganda, adding legitimization of Ukrainian efforts. But especially as far as the international law is concerned, they add additional layer of obligation and responsibilities of the invader. And in that sense, strengthen the Ukrainian position in the international community. I'm just looking whether I have, I think, 3 more minutes. Because at the end, I would like to move to the third point concerning the capability of Ukrainian courts and how it looked like in Poland after the World War II and how we have it here now in Ukraine in relation to the conflict in Ukraine. So during the ongoing hostilities, the Polish government in exile and underground Polish government in Poland were not able to prosecute war criminals. It's obvious. The underground courts were operating, but they were focusing mostly on collaborators, so Polish citizens. the approach was more towards direct hits against German war criminals. As probably the most known example was the assassination of Franz Kutscher in Warsaw, who was the leader of SS and police in Warsaw, responsible for many crimes on the civilian population. But also after the war, it was extreme effort to prosecute international war criminals, German war criminals in Poland, because I tried to pull some statistics. At least 60% of defense attorneys perished during the conflict, and at least 90% of advocate apprentices perished, were killed or murdered during the war. I think, this is from my head, I think it's 80% of judges were perished as well. Also the court buildings were in ruins. The Supreme Court, for example, building in Warsaw was totally destroyed, so the Supreme Court was operating from Łódź for at least till mid-50s until it was rebuilt. So this was the situation back in Poland, really. As far as the capability of Polish judicial system to prosecute war crimes. There were also very serious logistic problems concerning the extradition of to Poland of German war criminals. One of the reasons why not so many were extradited was the fact that Poland was not able to secure transportation modes for those apprehended in Germany or other countries. Nevertheless, the situation is again quite different in Ukraine. I had some statistics from April 2022. Only 20% of courts are not functioning, and they're mostly the courts in controlled, occupied territories, territories controlled by Russia. So we see that the judicial system is still quite capable of, as far as institutions are concerned, for prosecuting war criminals. They also have some experience in the sense that there were already, starting from 2014, quite a few criminal proceedings of war criminals after, of course, the annexation of Crimea and Donbass. The national legislation provides for war crimes prosecution. Maybe it's different because it's rather by implementation of international standard than providing standards of the elements of crime in national legislation. But still, we have war crimes penalization. We have penalization of aggression, of war of propaganda. There are, of course, also the courts that are able to collect evidence and have much better access to victims. They know the language of the victims or perpetrators and know the context of the struggle. I have here information concerning the pre-invasion period as far as the experience of Ukrainian courts are concerned. There were 397 proceedings, but only 3 verdicts were issued. Now I think that the Office of Prosecutor announced that there was at least 47,000 instances of alleged crimes of genocide, and those are being investigated also with the international help. So despite certain concerns, especially as far as the judicial independence is concerned in Ukraine, I think that we all agree that the Ukrainian courts are the best option for prosecuting war criminals. We of course have the first case, the famous case of Vadim Shishimarin from May 2022, that was also quite publicized in international media. The tank commander who killed a civilian, and he was sentenced first to death and then to. And his sentence was reduced to 15 years by the Kiev Court of Appeal. And even in the jurisprudence of Ukraine, we can see some developments of international criminal law that I think are quite interesting, and we probably will see more of those. 2 examples I would like to say is, first that I would like to mention is the crime of aggression, that of course at international level is only a leadership crime, but in Ukraine is construed much broader. So also the foot soldiers can be criminalized for the crime of aggression. And secondly, the Ukraine also provides us, in the case of Yushchenko, the first instance, the first case when the head of state, former head of state, was prosecuted for the aggression against its own state. So it's also quite an interesting factual background, at least. With that, I would like to finish with a call to the academic community, especially to the Ukrainian part of that. After the war, the Second World War, Poland was probably one of the few countries that were really focused on prosecuting war criminals. But unfortunately, these efforts were not visible in the international community, also academic and political one. Due to different reasons, of course, political as well, because of the Cold War divide, but also because of the inaccessibility of judgments. So I think there's a good time also to make sure and think about how to make this effort of prosecuting war criminals, how to make this experience of Ukrainian courts visible in the international community, to make those judgments public, accessible to the broad audience. Because when we discuss, for example, Holocaust crimes or crimes or Nazi crimes, we don't really mention trials of Rudolf Höss, for example, or first Auschwitz trial that did not take place in Frankfurt or anywhere in Germany. It took place in Krakow, where the first commandant and creator of the Auschwitz camp was prosecuted and sentenced to death, as well as 40 other staff members. This is not known generally, and this is something that was lacked after the World War II. So I think this is also a possibility to make this experience of prosecuting war criminals from this region of the world also visible and heard in the national community. Thank you very much.
Thank you very much, Dr. Kutz, for your remarkable paper that gave this very important comparison between Poland and Ukraine. And now we can move on to our last paper, which is going to be given by Dr. Yurii Kaparulin. And our speaker is now a visiting fellow at the Weiser Center for Europe and Eurasia at the University of Michigan. He's also a director of the Raphael Lemkin Center for Genocide Studies, associate professor in the Department of National International Law and Law Enforcement of the Faculty of Business and Law of Kherson State University. He studies the history and law of Eastern Europe. In particular, he is interested in Holocaust and genocide studies, human rights and crimes against humanity, and political repression in the Soviet Union and World War II. The results of his research have been published in well-established international journals, and he's also a commentator in the popular English-speaking media like BBC News Ukraine. Dr. Kaparulin has held numerous fellowships, most recently in 2022 in the Center for Holocaust Studies at the Institute for Contemporary History in Munich. And at our conference, he is going to present the paper, The Crime of Genocide in the History of Ukraine, Legal Regulation and Historical Reflections.
Thank you so much for introduction. Thank you, dear colleagues, for your interesting talks today, and thank you, Pilecki-Institut, for inviting me. I would bring your attention to the topic about what is genocide crime in the contemporary legislation system in Ukraine. And I would start from some historical overview. So in the early 1950s, several years before the death, Raphael Lemkin returned to his research on the Soviet genocide in Ukraine, which he apparently wanted to condemn no less than Nazis' Holocaust. However, the crime of the Soviet regime were never internationally condemned and were conceived for decades, and generally speaking, Lemkin's ideas as well as Genocide Convention itself were not in sufficient demand during the second half of 20th century. No wonder researchers on topic say that Lemkin's ideas were forgotten and rediscovered several decades after his death in 1959. As for convention, its application was first made only in 1998 during the International Criminal Tribunal for Rwanda. It's important to note that by the end of the 20th century, the concept of genocide went beyond the purely legal plane. It was implemented in the national legislation of many countries. At the same time, researchers of mass violence began to use the concept of genocide in a historical or political context, in particular in relation to events that occurred before the adoption and ratification of Convention of Genocide. And at the political level, acts of genocide began to be used to describe colonial and other crimes, such atrocities against Native Americans, people in the United States, or the genocide against the Guerrero or Nama tribes by Kaiser Germany. Indeed, when the Lemkin was working on the concept of genocide, he necessarily relied on past precedents to explain a phenomenon that objectively existed in human history long before adoption of the Genocide Convention. In other words, he successfully combined the legal and historical implementation of the genocide, which today are relatively independent areas, although they require careful coordination. For the last 30 years, Ukraine has been in a state of overcoming the influence of the Soviet totalitarian past, during which massive gross human rights violation and crimes against humanity took place. In particular, over the past decades, attempts have been made at the legislative level to incorporate the norms of international law on the crime of genocide into international legislation. On September 1st, 2001, the Criminal Code of Ukraine, new Criminal Code of Ukraine, came into force, replacing the Criminal Code of the Ukrainian Soviet Socialistic Republic of 1960. And new code included Article 442, which defines the crimes of genocide and its liability for it. And at the same time, Ukraine is rethinking its strategic past, resulting in official political decisions to recognize the past events as examples of the genocide. Such decisions are formalized in special laws and individual resolutions of Verkhovna Rada of Ukraine, the cabinet minister of Ukraine, and decrees of the president of Ukraine. For example, on October 8, 2004, in prevention for the International Day of Commemoration of the Roma Genocide, in particular, Verkhovna Rada of Ukraine adopted a resolution on the commemoration of the International Day of the Roma Holocaust. In 2006, the law of Ukraine about the Holodomor of 1932-1933 in Ukraine was passed, and Article 1st defines the Holodomor in Ukraine as a genocide of the Ukrainian people. Paragraph 2 of the decree of Verkhovna Rada of Ukraine of July 5th of 2011 was also established to commemorate Holocaust Memorial Day on January 27 every year. In 2015, after Russian war started against Ukraine, Verkhovna Rada also passed a resolution on the recognition of the genocide of the Crimean Tatarian people, and it was a new step to rethinking the national history of Ukraine, which was caused by the annexion of Crimea by Russian Federation and the beginning of the war in eastern Ukraine. This decision received solid support from the officials in Ukraine and abroad, and from many people who supported Ukrainian singer Jamala during her performance and victory at the Eurovision Song Contest in 2016 with the song 1944. Thus we see that the recognition of the genocide format a peculiar hierarchy of legislation, from special laws to individual clauses of the resolutions of Verkhovna Rada of Ukraine. On June 3rd, 2021, at the first reading of the Verkhovna Rada of Ukraine, the draft law on prevention and combating anti-Semitism in Ukraine was also passed, and Article 2 states that denial of the persecution and mass murder of Jews during World War II, the Holocaust, can be considered an example of the anti-Semitism. As a result of full-scale invasion of Russian Federation in the territory of Ukraine after February 24, 2022, massive crimes against civilians were committed and accompanied by the destruction of the infrastructure of both larger cities and smaller settlements. In the first weeks of the war, it became apparent that this violence could not be explained by the accompanying risks that accompany any hostilities. The torture and murder of people who actively or passively resisted the Russian military, together with the destruction of schools, universities, museums, theaters, and other cultural sites that had no military significance, gave reason to talk about some special intent of such actions. Relying on the sources of international humanitarian law, in particular the provisions of the Convention of the Prevention and Punishment of the Crime of Genocide and Article 6 of the Rome Statute of the International Criminal Court, the Verkhovna Rada of Ukraine decided to approve the declaration of Verkhovna Rada of Ukraine, named on the genocide commitment by the Russian Federation in Ukraine. In the explanatory note of the resolution, the Parliament identified 5 case aspects. You can see it on this slide. So, justification of the need to adopt the resolution, goals and objectives of the resolution, general characteristic and main provisions of the resolution, financial and economic justification and justification of the expected social, economic, legal, and other consequences of the application of a resolution after its adoption. In particular, considerable attention was paid to the characteristic of the policy of the Russian Federation towards Ukraine in recent years, which contributed to the routine of hate speech against Ukrainians and lead to an aggressive war. The continuity of this policy to the tragic events of the Soviet period of Ukraine history, in particular the times of Stalin and his genocidal policy, also was noted in this resolution of Verkhovna Rada. Thus, Ukraine continues to develop a legal framework that seeks to condemn genocide in the national history of Ukraine and to prevent the future recurrence of this crime. A critical view of history, the recognition of tragic events of the past, including genocide and their prevention and characteristic features of modern, it's a part of today's modern European civilization. But we must be careful and attentive to this. In the case of Russian war against Ukraine, we have faced falsifications and manipulations in this area. The full-scale invasion of Russian Federation into Ukraine on February 24, according to the Kremlin's official reports, was aimed at preventing a genocide of Donbas residents. But the good news for all of us that the international community passed this test and refuted this falsification. On March 16, 2022, the International Court of Justice refuted Russian claims of genocide in the Luhansk and Donetsk regions and stated that it was an attempt to distort the concept of genocide. It was a terrible manipulation, and instead the Russian leadership and the military restored to actions that today are required by international experts as having signs of genocide. An important aspect was to note a prospect for which the investigation of crimes of Russian Federation in Ukraine is not limited only to the investigation of the crime of genocide. Also, our parliament say to Prosecutor General Office and Ministry of Foreign Affairs of Ukraine and the Ministry of Justice of Ukraine were instructed to take measures to properly document the facts of the crimes against humanity, war crimes, and other serious crimes on the territory of Ukraine. This will allow for a more flexible policy in investigation initiated in Ukraine and abroad. Returning to the events of the present in connection with the events of the past, I want to say that the current aggression of the Russian Federation against Ukraine became possible in particular because the crimes of the Soviet regime were never prosecuted at the international level after the events of the Second World War, and it was impunity that allowed the firstly Soviet Union and then Russian Federation to hope that in the future the world would not react to aggressions against neighboring countries. Thus, a number of genocides have been recognized at the legislative level in Ukraine since independence. Most of these events were mainly of symbolic and political significance as they related to the events of the distant past. For its part, the Russian Federation continued to deny the existence of specific genocidal intent from her side, and in particular in relation to the Holodomor and deportation of Crimean Tatars. As we know, the denial of the genocide itself, it's one of the stages of committing this crime. Thus, Russian aggressive war against Ukraine was condemned as genocide at the highest level in Ukraine. And today we cannot prevent what happened on February 24 and previous years, but we can still condemn the aggression by breaking its history of impunity. Thank you so much.
Thank you very much, Dr. Kaparulin, for your paper. And now we can move on to the discussion. Unfortunately, due to the technical issues, we started a little late, so we don't have that much time for a discussion. We should have ended our panel right now, but I will extend the discussion until 11:10, and so please feel free to ask questions to our panelists, but I would like to ask you to keep your questions very brief.
Hello, my name is Mateusz Werner, Pilecki-Institut. I would have a question to Mr. Yurii Kaparulin. What is so far the reaction of international bodies, international courts, European Union, United States bodies to this declaration of Wierchowna Rada from 14 April 22?
maybe we collect 2 or 3 and yes.
Karolina Wierczyńska, Polish Academy of Science. Thank you very much for all your very interesting presentations. I have a question to Tomasz Lachowski. We know how to define genocide, but I'm very curious not about the intent this time, but how do you define the group? Who are Ukrainians? I would be very grateful for your answer. Thank you.
Somebody else?
Thank you very much for all your presentations. I have the question to our last speaker. Could you please say something more about proceedings before Ukrainian courts right now, after 24 February?
The last question?
First, a very good panel. The question I have is, given the circumstances which have been described here, in which genocide was coined by Raphael Lemkin, and also the Holocaust, it became indelibly associated with the Holocaust, which is one of the reasons that the term is now often used as a kind of political weapon, because that is seen as such a glaring case of mass murder. That it in a target group that had done nothing against the perpetrators, and so the problem in thinking about using that term nowadays is that it has gotten politicized, because those who have suffered great harm see it as necessary to have that crime characterized as genocide, to ensure that they too will be seen as the kind of obvious victims that the Jews and the Roma were of the Nazis. So I'm wondering whether it would be better, even though it's not going to happen, but it would be better to stick with crimes against humanity. And one last point on that is crimes against humanity can also encompass egregious cases of mass murder that are not easily covered by genocide, at least genocide as it's defined in the convention, such as the murder of 2 million Cambodians by the Khmer Rouge. So that when the Extraordinary Chamber in the Court of Cambodia was set up, it did speak about specifically about crimes against humanity because of that question, that genocide was not easily applied to what had happened there.
Thank you.
I should start? Who starts? Yeah, I can start. Thank you, Professor, for your question about a Ukrainian national group. I perceive Ukrainian national group concerning their feeling as a member of political nation of Ukraine. So I do differentiate between ethnicity and not just nationality in terms of citizenship, but the feeling of being an Ukrainian. And if we look at those victims of Russian crimes on the temporarily occupied territories, like in Bucha, but also in the south and in the east, like I said during my presentation, there were many people of different ethnical origin, like even Russian. However, they feel themselves to be a member of a Ukrainian national group. So national group, in terms of the convention, I perceive more as those ties with a state, if a state exists, because of course sometimes nations do not have their own states, not just on this, let's say, ethnical ties as it is on this, let's say, lower level. So, for instance, the minorities within the bigger national group. So that's why I'm arguing that the genocide is being committed against the Ukrainian national group, and as Lemkin perceived the same in this famous 1953 paper, when he perceived Ukrainian peasants not as a social group, but as an emanation of the Ukrainian national group during the Soviet times. So that's my brief answer. Thank you very much.
Yes, thank you for your question. I would say, actually, I don't know many reactions. I'm not studying especially this question, how many reactions were outside of Ukraine on the adoption of the resolution of Verkhovna Rada in April 2022. Maybe because it was start of the war and many events happened this time, it was not so important to talk about some laws, bills, declarations, because it was a time when we didn't know if Ukrainian state will be in next months at all, you know, because it was period of escalation, and so I can't say about a lot about reactions, but no, I know any reaction from Russian side on this resolution, and but I'm sure they will deny how they deny all previous resolutions about genocide examples in Ukrainian history committed from Kremlin's leaders. So yeah, maybe it's topic what we should to study more. What was reaction on this resolution during last year? But for me, it's important that Ukraine show that we're ready to lead international community and not only not only prosecute this crime of genocide on our national level, but we also started this process and this discussion on international level. And this resolution was translated in English. You can easily find it on the official website of Verkhovna Rada of Ukraine. Thank you.
There's still a question asked by Professor Kramer, who would like to.
Yeah, actually, I agree with you that. The genocide concept is politicized, and I think it has already been politicized during the Cold War. So I was mentioning that in the case of West Germany, so it was incorporated in the West German Penal Code on the basis of a very odd alliance between Raphael Lemkin and the anti-communist expellee groups, very odd alliance. So, and I can also understand why somebody like Anton Weiss-Wendt, for example, he argues that in a way the genocide concept has been discredited by this propaganda struggles during the Cold War, so we shouldn't use it anymore. But on the other hand, I must say, as a historian, I can't accept this because genocide is a very, very important concept of the 20th century, and we have to deal with this. We have to, ask what are the ideas behind this concept. And I gave this talk, I think it was 1 year ago here at the same place on Raphael Lemkin. And I think one dimension of this concept is also that it is meant as a warning to the international community. So, I mean, it also implies that genocide is committed, or mass crimes are committed when there's indolence, or when there's complacency, when there's complicity. And I think this is a very important dimension we have to think about in the future. I think this is one of the one of the meaning of genocide, that this is happening. Usually mass crimes are happening in a certain international environment when where states are not, they are reluctant to get involved, reluctant to interfere, reluctant to raise their voices. And this has been a phenomenon in the second half of the 20th century, despite the fact that we have this multilateral architecture, these multilateral institutions. So.
If I may, I'll just add one word, because I also share this view that the crime of genocide, or the concept of genocide, is somehow bigger than it's in law. And I have the feeling, unfortunately, that many judges, maybe I'll just put it like that, are too afraid to refer to the crime of genocide, and they prefer to go with crime of against humanity, not because of the legal considerations, but because of this political weight that this term have. So of course there are differences, and of course there is this part, especially of the intent as far as genocide crime is concerned, that is somehow difficult. But we are dealing with crimes like that on the national level every day, as far as evidentiary proceedings are concerned. It's the weight of the term, and I think we should pass that. I think that we should come back to the regional understanding of genocide. It shouldn't have this weight. We should come back to this understanding that the crime of genocide is committed, and there should be prosecution for those crimes. And especially the international judges should not be afraid to convict criminals for genocide.
Yeah, I just want to agree with my colleagues and just add a couple ideas. So I believe between lawyers, historians, social science scientists who study the topic of genocide or crimes against humanity, it's today it's clear that the genocide, it's not a crime of crimes. It's lost the status, and understandable that crimes against humanity, they are not less than genocides. And in legal aspect, I agree. Maybe in some cases, and with the case in Ukraine, we should start prosecution and we start trials not from prosecution of crime of genocide, but from the crime of aggression, war crimes. It will be more pragmatically like right now. But it's not. It doesn't mean we should just deny genocide like concept. It's a very important concept for understanding history and policy of states. And in examples of Ukrainian cases, I would say we really, I believe we really had several examples of genocide in our 21st centuries, in our history. And we say about this not only in political reasons, but because it were real events what we should talk about. And yeah, it's a part of a big process of rethinking our history. And tomorrow, I believe we will have a great discussion with Professor Gricak. Yes, thank you. Professor Gricak, who study this topic on highest level in Ukraine, about modern Ukrainian memory and rethinking the history topic. Thank you.